The other two cases,
What else does she have?
criminal trespass, and I didn't look at the other one.
Oh, there is a criminal trespass? Is it?
It's not filed there.
Oh, okay. We'll just decline them if they're not filed.
One.
Yeah.
Wanda, you're not on mute. Your Honor.
Yes, ma'am. Yes, ma'am.
We're ready when you are.
Ready to go? I'm also ready. Mr. Manning, who would you like first?
We're gonna start with Mr. Parker.
All right, Mr. Parker, if you'll come on up. This is cause number CR 24-184, State versus Kevin Winford Parker. Is Mr. Parker doing a plea today?
Yes, Judge, before we begin, there is one question. So, previously in our negotiations, there was not a amount provided for restitution, nor was there any documentation outlining what the restitution was gonna be asked for. I guess my client at this point would request that if we would be able to have a restitution hearing, just to see what supporting evidence there was for $3,595 worth of restitution.
Ms. Curry, any opinion on that? Ms. Curry, can you hear us? Ms. Curry?
Okay.
There you go. Did you hear Mr. Manning at all?
No, I did not, Judge.
All right, this is Kevin Parker, CR 24-184. I inquired if Mr. Parker was going to enter a plea today. Mr. Manning indicated yes, but he said that what is different or new about this they were unaware of was that now there's a claim to restitution, and he said there was no evidence attached to the plea to support that amount, and he was asking for the court to consider doing the plea but granting a restitution hearing. Is that something that you're opposed to, or is that part of the plea, or what would you say on the restitution?
We're fine with the restitution hearing, Your Honor.
Okay, do we want to go ahead and negotiate and do the plea today and strike the restitution amount, and then just go ahead and do the plea today and withhold the judgment until the time that we do the plea? Do you want me to go ahead and convict him today?
That'd be
Or
fine.
okay.
That works for us, Judge.
Okay, all right, Mr. Parker, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Your name is Kevin Winford Parker, is that correct?
Sir.
And make sure you speak up for me. Mr. Parker, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done as your attorney?
Yes, sir.
Do you have any questions about your plea agreement today?
No, sir.
Where you signed your plea agreement, is that your true and correct signature? And did you only sign once you were confident you understood what you were signing?
Yes, sir.
Mr. Manning, do you believe Mr. Parker to be competent today?
I do, Judge.
And do you believe that he's entering into this agreement intentionally, knowingly, and voluntarily?
I do.
All right, Mr. Parker, you are charged by indictment with a second-degree offense of burglary of habitation. That does have a range of punishment with a minimum 2 years in prison to a maximum 20 years in prison, and also a possible fine not to exceed $10,000. I see that the plea agreement in your case, upon your plea of guilt, the DA's office is recommending that the court consider the evidence and follow a plea agreement wherein you would be assessed 5 years punishment in the Texas Department of Criminal Justice. You would be ordered to pay a $1,500 fine, $290 court cost, $20 in reimbursement fees. The DA's office would be asking the court to consider and dismiss their unfiled engaging in organized criminal activity. You would receive from today, you would receive 251 days credit towards your sentence from the time that you have already spent in jail on this cause. And after today, the court would set you for another hearing to determine whether or not restitution would be ordered by the court with regards to this plea agreement. Is that your understanding, Mr. Parker?
Sir.
Okay. Mr. Parker, then how do you plead to burglary of a habitation?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Mr. Parker, has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence supporting the plea?
You know, Judge, I apologize, but I was going so fast earlier. I don't remember seeing a stipulation of evidence for Mr. Parker.
I emailed it to you, Mr. Manning, during lunch.
Ah, okay. Judge, we did not go over a stipulation of evidence for Mr. Parker. However, if you give me just a moment.
Sure, yeah, take just a moment. Do that.
Ms. Curry, how was that sent?
It's sent from Aaron McLeish's email because my computer is broken.
Ah, okay. I don't see. Oh, you know what? She may have sent that to my personal email. Give me just one moment.
And Mr. Manning, if you do have that, could you forward me a copy as well?
Yes, Judge. Give me just 1 second.
Judge, what email do you want? I'll send it to you.
I'll send it to you in a message.
Your regular one that comes up on the county?
Yes, ma'am.
Okay, I just sent it to you, Judge.
All right.
It's coming from Aaron's.
All right, I did receive that, Ms. Curry. Thank you.
And Judge, he acknowledges the stipulation is true and accurate, and we will execute a copy of that once I can get it printed out.
Okay. All right, the court admits the stipulation of evidence, and the court also takes judicial notice of Mr. Parker's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Rest and close, Judge.
All right, court will consider the evidence. All right, the court, having considered the evidence, finds sufficient evidence to convict the defendant. The court will follow the plea agreement today. Court hereby convicts Kevin Winford Parker of burglary of a habitation, a second-degree felony, assesses punishment at 5 years confinement in prison. Court assesses a $1,500 fine, $290 court cost, $20 in reimbursement fees. Court dismisses under section 1245 of the Texas Penal Code, cause number DA 2024-621, engaging in organized criminal activity. The court awards Mr. Parker 251 days credit towards his sentence for the time that he has spent in jail on this cause. And the court will set Mr. Parker for a restitution hearing.
Judge, you want to do that on the 20th?
I was going to ask if that was going to be too soon. Ms. Curry, that's a week from now. What do you think about that?
That's fine, Your Honor.
Okay. All right. Then the court sets Mr. Parker then for restitution hearing on this matter, February 20th. And instead of completing 2 judgments, give me your advice on that. Should we just withhold issuing a judgment, rendering a judgment until the 20th?
I don't see any problem with that, Judge.
The only thing I would be concerned about is how TDC calculates his credit time. If I pronounce 251 today and we don't do the judgment until a week from now, we either need to adjust the credit time to 258, or we'll need to do a separate judgment on restitution. So be thinking about that. If we need to go ahead and just strike the restitution today and we can enter this judgment, then if I find any restitution, I could issue another judgment at a later date. Usually we don't do the judgment until we've had the restitution hearing, but
If we go ahead and do it today, Your Honor, I think that gets him in line to catch chain, as they say, sooner.
yeah, that's what I was thinking as well. So
And
let's,
Judge, it hasn't happened on any of my cases, but I know in some cases in the past, I've seen that the judgment will say restitution to be decided at a later date, and then that's how they, I guess, mark that. So I'd be fine if we want to do that, and then have the hearing on next Thursday. And if we need to amend the judgment at that point in time.
okay, let's do that. So just go ahead and we need to have that restitution amount removed. And then just don't put anything in there or put TBD. And then we'll have him fingerprinted on that. And then if we need to amend it later, we can do that.
Thank you, Your Honor.
All right, Mr. Parker, you are hereby remanded to the custody of the sheriff so you can carry out the terms and conditions of the sentence. We'll have you back in court next Thursday at 1:30.
On the back's fine.
All right, who's next, Mr. Manning?
Mr. Jesus Aguado?
All right, Mr. Aguado, is Mr. Aguado entering a plea also?
He is, Judge.
All right, Mr. Aguado, this is cause number CR 24-252. Sir, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. I've got a question. On this
Yes, sir.
paperwork, it says Jesus the fourth Aguado. Is that correct? Or should it be Jesus Aguado the fourth?
Aguado the fourth.
Aguado the fourth? Let's see, this is going to be misdemeanor time. If this is just going to be misdemeanor time and it's not going to be affected by TDC, then what I'm going to do is I'm going to mark through the judgment. It doesn't matter to me if you mark through the remainder of the documents, but it might be best to do that. I'm going to modify the judgment just by interlineating the fourth and putting it after his name.
No objection to that, Judge.
All right, so Mr. Aguado, if you'll raise your right hand. Did I just place you under oath? I
Yeah.
did. Okay, sorry about that. I forgot. All right, so Mr. Aguado, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And Mr. Aguado, have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Manning. Are you pleased with Mr. Manning and the work he's done as your attorney?
Yes, sir.
Do you understand everything that you have read and signed in your plea agreement?
Yes, sir.
Is your signature your true and correct signature that you signed once you understood what you were signing?
Yes, sir.
Do you have any questions about your paperwork or anything else on this case before we go further?
No, sir, I don't.
All right, Mr. Manning, do you believe Mr. Aguado to be competent to enter into this agreement? And if so, do you believe that he is entering into this intentionally, knowingly, and voluntarily?
He is competent. I believe he is entering into the agreement intentionally, knowingly, and voluntarily.
All right, Mr. Aguado, it appears to me that you were originally indicted with a second-degree felony offense of aggravated assault with a deadly weapon. However, it appears that the plea agreement you've reached with the state is that you would plead guilty to a lesser included offense of a Class A misdemeanor terroristic threat of a family or household member. A Class A misdemeanor carries a range of punishment of not more than 365 days confinement in a county jail, and also a possible fine not to exceed $4,000. I see the plea agreement is you would plead guilty to that crime. You would be convicted of that crime. You would be sentenced to 158 days in the county jail. You would be given credit for 158 days of time already served. And you would also be fined $500. You would also be ordered to pay court costs of $290 and reimbursement fees of $535. Is that the plea, Mr. Aguado, that you're asking the court to approve?
Yes, sir, that is.
All right. All right. So, Mr. Aguado, how do you plead to terroristic threat of a family or household member, a Class A misdemeanor?
Guilty.
Are you pleading guilty to that crime because you are, in fact, guilty of committing that crime?
Yes, sir.
And Mr. Aguado, has anybody threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
All right, the stipulation is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Question closed, Judge.
Ms. Curry, is the DA's office in compliance with victim notification on this? I just see it's a crime of violence against a person. Is there any support for the plea or non-support for the plea or any kind of response whatsoever?
Judge, we are in compliance. I am unaware of what the victim's response. I take that back, Your Honor. The victim here did not want us to do even this much.
All right. Anything else from the defense, Mr. Manning?
No, nothing at this time, Judge.
All right, court is going to review the evidence. Let's see, my stipulation of evidence says that it just stipulates that the allegations in the indictment are true. But I don't have a copy. Let me,
Here, Judge.
okay. Is that the, okay. My stipulation, is that a different stipulation, I guess?
Yes, Judge.
Okay. Let me make this bigger so I can see. All right, thank you. All right, court, having reviewed the stipulation of evidence, finds that there is enough evidence to substantiate the guilt of the defendant. Court will follow the plea agreement today. The court convicts Jesus Aguado IV of terroristic threat of a family or household member. A Class A misdemeanor, assesses punishment at 158 days in the Van Zandt County Jail. Court orders that he receives 158 days credit for time already served. Court orders him to pay a $500 fine, $290 court cost, and $535 in reimbursement fees. Mr. Aguado, once you are released from custody, you are obligated to pay the fines, court costs, and reimbursement fees. If you cannot pay those all at once, then you need to report to the district clerk's office in the courthouse and make arrangements to begin a payment plan. Failure to report and pay or failure to report and set up a payment plan may result in this court issuing another warrant for your arrest. Do you understand?
Yes, sir.
All right, Mr. Aguado, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Who's next, Mr. Manning?
Judge, I believe that Henderson County may be online for Mr. Hubbard.
Yeah, I believe they are. Let's try to bring up.
You send it to my email and I'll forward it to Aaron and I can do it off of that.
Okay, because I did send it.
Okay.
You should be getting the electronic on here.
Okay.
That okay there?
Hello?
Can I hear you and see?
Yes, Mr. Hubbard, can you see and hear me okay?
Yes, sir.
All right, I'm seeing you and I'm hearing you well. Can you see your attorney, Mr. Manning?
Yes, sir. Yes, sir.
Excellent. All right, I'm gonna go ahead and call your case. This is cause number CR 24-75. State of Texas versus Timothy Wade Hubbard. Mr. Hubbard is appearing in court today via Zoom from the Henderson County Justice Center. And Mr. Manning, I believe that Mr. Hubbard is set for docket call.
Yes, Judge, at this point, I still have not had an opportunity to go over discovery and to speak with Mr. Hubbard in person. We were waiting on his case being resolved down in Henderson County. And so I'd request additional setting on Mr. Hubbard's case.
Do we have an ETA on his resolutions there or his next hearings there?
My understanding was that he was supposed to have had that earlier last week. I may be mistaken, but if my memory serves me correct, he was supposed to have had a hearing on his case prior to this setting today.
Mr. Hubbard, have you been in court in Henderson County recently?
On January 8th, I signed for 10 years TDC, and I've already signed. I said that was like on January 8th. That's what I said last time. I
Signed.
don't. Yeah, I
Okay.
signed for 10 years TDC. I'm waiting on Chain.
Okay.
I don't have any more court dates here in Henderson County.
All right. Mr. Manning, do you want me to get, I'm not sure if they're gonna let us have him if he's already got a TDC ticket.
Judge, let me propose this. In the effort, in the essence of judicial economy, and with our new setup, would you like for me to try to go down to Henderson County and attempt to plea him from there with the new e-sign system?
I would like that, sure. You want me to reset this for next Thursday and we'll see what we can do between now and then. If not, I think what'll happen is he'll catch the TDC chain and then we'll have to go pick him up and bring him back. Cause I just don't think Henderson County is gonna, I don't know that they're allowed to let me bench warrant out when they've already asked TDC to take custody.
Yes, Judge. I would ask actually if we could set that on a non-court day. Because, well, unless we need to go down there and sign it and then have him present via Zoom on court day. What would your preference be?
I guess explain that to me again.
Would you prefer that the paperwork be signed simultaneously with our court hearing? Or do you care if I go down there on a non-court day, get it signed, and then we just present that on a court day?
Either way.
Okay.
Either way, fine. We'll just have to, when you go though, we'll have to have him fingerprinted by the Henderson County Jail. We'll need to take our fingerprint certificate and have him sign it and fingerprint it so it can be attached and filed here to our judgment. So.
Yes, Judge. I will, I'll see if I can arrange that between now and next Thursday. And if we can just reset him for next Thursday, I'll get down there and try to get this squared away.
Okay. All right. So Mr. Hubbard, we're gonna set you for February 20th. I'm not gonna do a bench warrant and have you brought out. Mr. Manning's gonna come see you there in Henderson County. And if something can be worked out, then we'll do all that electronically and we'll have another hearing and get you pled out and get you resolved. Okay.
All right, thank you.
You're welcome. Tell the jail staff at Henderson County I appreciate their efforts in getting you zoomed in today. Okay.
Yes, sir. Thank you.
All right, Mr. Manning, who are you ready on now?
Judge, already on Ms. Carter.
Anne Marie Carter, CR 20-204. All right, Ms. Carter, the state had filed a motion to revoke your community supervision. Earlier today, they filed a motion to withdraw that motion to revoke and indicate that there's an agreement between you and them in which they would withdraw their motion. You would be continued on community supervision and your probation period would be extended for an additional 5 years. You would be placed on intensive supervision. You would serve 120 days in the jail. You will receive credit for that time served. And you would do that as a condition of your community supervision. So let me ask you to raise your right hand so I can place you under oath. Ma'am, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, thank you, lower your hand. All right, so Ms. Carter, is that your understanding of the agreement between you and the state to resolve your motion to revoke?
Yes, sir.
All right, and you understand also, Ms. Carter, that should you later receive another motion to revoke, if you were to be, your community supervision were to be revoked and you were to be sentenced, you would not receive credit for 120 days that you're doing as a part of your modification today. You understand that?
Yes, sir.
So you will in essence have lost that time and you won't get credit should you need it in the future.
Yes, sir. I won't need it in the future.
That's what I wanted to hear. I was about to ask you, in your own words, and Mr. Manning can help you if needed, but why should I allow you to continue on probation in light of their motion revoke?
Sir, I just got out of prison. I got my GED and I learned I don't want to go back to prison. So, I mean, I want to go back to school, something I never knew I wanted to do before I got my GED, you know. I have a new outlook in life, you know. I want things I never wanted before.
Okay. Okay, then what I'm going to do, Ms. Carter, and finally, I need to ask you, has anyone pressured you, forced you, made you feel like you had to make these agreements today?
No, sir.
Okay. All right, then what I'm going to do, Ms. Carter, is I'm going to take you at your word. I'm going to give you another opportunity, but I want you to understand that this is not a game of baseball. There's not 3 strikes. Okay. So if you get another revocation, despite what you may want, you may get something other than what you want. You understand what I'm telling you?
Yes, sir.
All right, court grants the state's motion to withdraw. The court will amend the conditions of community supervision to include an extension for 5 years, that Ms. Carter be placed on intensive supervision, that she serve 120 days in the county jail, that she be given credit for 120 days of time already served. All right, so Ms. Carter, you're continued and extended, and I hope that these new things that you want in life will give you the motivation to be compliant on your probation.
Thank you.
You're welcome. Who's next, Mr. Manning?
Judge, I have the paperwork from Mr. Dennis. There's one correction that needs to be done on one of the judgments. But other than that, everything else is correct. I don't know if we want to proceed or we want to wait till that is corrected.
Well, go ahead and tell me, what is it?
So on the evading arrest detention vehicle, the agreement we had was for 3 TDC instead of 5. But other than that, everything else is correct on the remainder of the paperwork.
Okay, so 3 years instead of 5, jail credit, everything else is correct?
Yes, Judge, my client did have a question on the jail credit, but Ms. Abney was able to provide the dates that she was able to locate, and that satisfied my client's question on those dates.
Okay, well, no, let's go ahead and we'll go ahead and do the plea, and then we'll just make sure that I get the proper judgment. If you will, in any of the remaining documents, if you'll just interlineate the 5 put 3, initial it, then the only clean copy we'll need is the judgment.
Yes, Judge.
All right,
Judge, and I apologize, actually, there was on the third page where they had the punishment options, it looks like something happened where there was an insertion of text. I don't know if that's on yours as well, but under punishment options, that final one, it looks like it recites the stipulation of evidence in the judgment. I just noticed that.
you said on page 3.
Page 3 of the judgment, sorry, 2 of the judgment.
Let's see here. Yes, I do see. Yeah, it looks like the stipulated testimony has been inserted under the confinement as a condition of community supervision. So I don't know if you can see that, Miss Curry, or so I think right in here. Just make sure that Miss Abney removes that. This is on page 2 of the judgment.
Yes, Your Honor. Okay,
So she'll fix that while she's fixing the changing 5 to 3. All right, court calls cause numbers CR 24-130, 131, CR 23-10, and CR 24-96. Mr. Dennis, if you, and this is State of Texas versus James Dwayne Dennis. Mr. Dennis, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. It didn't come over audio. I saw you say it, but I didn't hear you. Can you just repeat it for me?
Yes, sir.
All right. Just make sure you speak up a little louder for me. I think the microphone's not picking you up very well. All right, Mr. Dennis, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you understand everything that you've read and signed that's part of your plea agreement?
Yes, sir.
The signature that's in these documents, is that your true and correct signature that you signed once you understood what you were signing?
Yes, sir.
Do you have any questions about anything involved in this, any of these cases before we go further? And you have to answer out loud.
No, sir.
All right, because I have a court reporter here and she's typing down your answers and my questions and all those things. Mr. Manning, do you believe Mr. Dennis to be competent today?
I do.
And do you believe that he understands his rights as they pertain to these cases and that he's entering into these agreements intentionally, knowingly, and voluntarily?
I do.
Very well. All right. So Mr. Dennis, I'm going to go in each case here. We're going to start with cause number CR 23-10. In that case, you are charged by indictment with a 3rd-degree felony offense of evading arrest or detention with a vehicle. That does have a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a possible fine not to exceed $10,000. I see that the plea agreement in that case, you would plead guilty to that crime. The state would be recommending that the court convict you, assess your punishment at 3 years confinement in prison, a $1,000 fine, plus court costs, plus reimbursement fees. And your sentence in this case would run concurrent with the sentence that would be negotiated in these other 2 cases, which are abandoning or endangering a child. In addition, the state is agreeing to dismiss the bail jumping case in which you were indicted. You would receive also 343 days credit towards your sentence for the time that you've spent in jail on this cause. That's in that case. In CR 24-130 and CR 24-131, in both of those cases, you've been indicted for abandoning or endangering a child, a state jail felony, and a state jail felony carries a range of punishment of not less than 6 months in prison or more than 2 years in prison, and also a possible fine in each case not to exceed $10,000. I see that the plea agreements appear to be identical. In each case, the state's recommending that upon your plea of guilt that you be convicted of each offense, that your punishment be assessed at 6 months confinement in state jail prison, that the sentences run concurrent together. That means at the same time. And that you be responsible for your court costs and your reimbursement fees. And finally, that you would receive 180 days credit on those sentences for time already served. And then lastly, of course, in the bail jumping case, the state filed a motion to dismiss that case. So, Mr. Dennis, is that your understanding of the plea agreement in each case?
Yes, sir.
All right, then let me ask you at this time, Mr. Dennis, how do you plead to evading arrest or detention with a vehicle?
Guilty.
And how do you plead to abandoning or endangering a child in each case, CR 24-130 and CR 24-131?
Guilty.
Mr. Dennis, has anyone forced you, pressured you, otherwise made you feel like you had to plead guilty to any crime here in court today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence supporting these pleas?
No objection to the stipulation as offered.
All right, stipulation is admitted in each case respectively, and the court does take judicial notice of the defendant's judicial confession. Ms. Curry, anything further from the state?
No, Your Honor.
Anything further from the defense, Mr. Manning?
Rest and close, Judge.
All right, court's going to review the evidence. Sure that I have stipulations here for me to review. Would you be kind enough to hold those up to the camera?
Yes, Judge. I'll hold up two of them. The stipulation for the abandoning and endangering is the same in both counts. This is for the evading.
Make this. All right, thank you.
And this is for the other two cases.
All right, thank you. In that stipulation, does it recite what the age of the children were?
It does not, Judge.
For abandoning or endangering, what is the age of the children? 14, less than 14?
Less than, I believe it's less than 15, Judge.
Less than 15. What I would like to do is amend those stipulations to include that, just so that there's no question about what age the children were at the time of the offense.
Yes, Your Honor.
So if you want to just write that in, Mr. Manning, and have your client, and you can even say, my children who were in the vehicle who were less than 15 years of age, and then just initial that. I'm satisfied with that. All right, the court, having considered the evidence, finds that there is sufficient evidence to convict Mr. James Dwayne Dennis of each offense. The court, in cause number CR 23-10, follows the plea agreement, convicts the defendant of the third-degree felony offense of evading arrest or detention with a vehicle, assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,000 fine, $290 court costs, $120 in reimbursement fees. The court orders the sentence to run concurrent with sentences in cause numbers CR 24-130 and 131. The court, as part of the plea agreement, dismisses cause number CR 24-96, which is a bail jumping. In cause numbers CR 24-130 and CR 24-131, the court convicts James Dwayne Dennis of abandon or endangering a child, a state jail felony. Court assesses his punishment at 6 months confinement in the state jail division of TDC, orders him to pay a $290 court cost and $70 reimbursement fees in each one of these cases, with those sentences to run concurrent with one another, and also cause number CR 23-10. Further, the court does award 180 days credit towards each of these sentences for time already served. Mr. Dennis, once you are released from custody, if you have not already paid off your fines, court costs, and reimbursement fees, you're ordered to report to the district clerk's office and make arrangements to have those paid. If you need to enter a payment plan, that's fine, but you need to show up, tell them that you need to take care of business. Your failure to do so could result in the court issuing a warrant for your arrest. Do you understand? All right, Mr. Dennis, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted.
And Your Honor, just one slight clarification, the pronouncement of sentence. What the court said was that these would be taken, run concurrently with one another, but the way I've explained it to Mr. James is that this will be run concurrent with any and all issues he has here or elsewhere. Mr. James is currently down in TDC on another charge, and so I explained to him, and so I just like the court to clarify that its pronouncement of sentence isn't making this case stacked with any other cases anywhere else.
Mr. Dennis, this court has not ordered that any of these sentences run consecutively to any other, so they're going to be applied under the law, which is they're going to run at the same time. I would have to make a specific order that they run consecutive to each other or any other case for them to be stacked. And I've not done that. Concurrent means run at the same time.
Yes, sir.
Okay. Who'd you like next?
Judge, let's start with Mr. Tyson Davis. And if we may have a copy of the indictment to view.
All right, this is cause number CR 24-310, State of Texas versus Tyson LaCruz Davis. Stand by just one moment. I'll have that displayed.
Thank you. Your Honor, my client's name is spelled correctly. He understands the charge as well as the range of punishment and pleads not guilty at this time. Judge, he does request an offer on this case, and if we can get an offer, we maybe even resolve him next Thursday, as this may be a mandatory probation case.
Okay. Court finds that Mr. Cruz, having waived the formal requirements of arraignment, enters his plea of not guilty into the record. And the court, I'm gonna set it for pretrial in March. If y'all get together and you want to work it out, the state wants to make that offer. If it is an auto deferred or something, then you can just notify Ms. Taberham that you want it set sooner. Otherwise, I'm just going to set it in March on the 27th.
Yes, Judge.
Have anyone else?
Next, Judge, ready on Mr. Dickerson. And if we can also have his indictment pulled up.
This is cause number CR 25-7, State of Texas versus Jonathan Lee Dickerson.
Judge, my client's name is spelled correctly. He understands the charge against him as well as the range of punishment, and at this time pleads not guilty and requests to be set on the pretrial docket for March 27th.
Mr. Dickerson, having waived the formal requirements of arraignment, the court enters his plea of not guilty into the record. Court sets Mr. Dickerson for pretrial hearing March 27th, 2025 at 1:30.
Thank you, Judge.
Who's next?
Excuse me, Judge, sorry. Dennis Jones.
Dennis Ray Jones, cause numbers CR 24-167, CR 24-274. Show that we're set for docket call on the firearm by felon and pretrial on the evading arrest.
Yes, Judge. I had an opportunity to go over the discovery, parts of the discovery with my client. And we would request an additional setting on the pretrial for the evading arrest. There may be some motions I'm gonna need to file, but we did not get to view the discovery until yesterday.
Okay, any objections from the state?
No, Your Honor.
All right, the court will set Mr. Jones for additional pretrial on the evading arrest, March 27th at 1:30. The court will carry docket call same day. Who's next?
Judge, I don't see Mr. Loden in here. Oh. Sorry. I looked right at you too. I was like, what's Parker still doing in here? I apologize, Judge.
I was about to call the sheriff and tell him Mr. Loden behaved or something. I couldn't find him. All right, this is cause number CR 19-23, State of Texas versus Justin Edward Lee Loden. Motion to revoke. Go ahead, Mr. Manning.
Judge, I've had an opportunity to speak to Mr. Loden regarding his motion to revoke, as well as to the probation department. And I've reached out with a potential resolution to the state. I understand that Mr. Hartwell is out ill, and so I request that we be reset on the motion to revoke.
You want to reset it next week on the evidentiary docket on the 20th, or reset it for the 27th? And if y'all work something out, you'll let me know sooner.
Judge, we can do the 20th.
20th? Any problem with that, Ms. Curry?
No, Your Honor.
All right, court will set Mr. Loden in for another hearing next week on Thursday at 1:30, the 20th.
And Judge, in my defense, Mr. Loden was sitting where Mr. Parker was previously, so. Judge, next ready on Mr. Teddy Robinson.
Eddie Maurice Robinson, CR 24-285. Mr. Robinson is set for pretrial.
Yes, Judge. I had Mr. Robinson on my schedule to meet with. However, the first week that I had him on, I was sick. The second week I was in preparation for trial, and so I have not been able to speak to Mr. Robinson regarding the discovery in his case and potential defenses. We request additional pretrial on this case.
Any objections, Ms. Curry?
No, Your Honor.
All right, court will reset Mr. Robinson to March 27th.
Judge, if we get a resolution prior to that, would the court entertain setting him earlier than that?
Yes, but yes, I think we would, because I did have 2 weeks set aside for trials. And so if we need to make some things happen, I do have some flexibility on that now, since those trials have resolved.
Thank you, Judge. Yes, sir. Judge, next we're ready on Mr. Rogers.
Joshua Paul Rogers, CR 25-26. Do you need the indictment on Mr. Rogers?
No, Judge, we had an opportunity to go over the indictment, and I believe we actually have an agreement. But I don't believe that the state was able to move forward with that agreement today. If you give me just one moment to pull up my notes. Judge, we did have an offer that he accepted, but I guess maybe it wasn't able to be completed before Mr. Hartwell got ill. Could we reset him to next Thursday? It's gonna be a probation offer.
Yes, court. Will, has he been arraigned?
No, Judge, no, his name is spelled correctly. He understands the charge against him as well as the range of punishment, and pleads not guilty.
Okay, all right, the court will enter Mr. Rogers' plea of not guilty into the record, finds he's waived the formal requirements of arraignment. Court will set this for plea on Thursday of next week, the 20th at 1:30. If there's an agreement with regards, if he's going to be put on probation and there's an agreement with regards to any kind of bond, then just send that over, signed and agreed, and then we could shift the hearing to 9 o'clock instead of 1:30. But I'll let y'all work that out amongst yourselves.
Yes, Judge. Okay. Fine.
Would you like next?
Judge, I believe this is Mr. Clayton Spencer.
No.
I'm sorry, James Walls.
Yes.
Where's Clayton?
It's okay, Mr. Walls, come on up.
Oh, okay. Okay.
All right, court calls cause number CR 25-27, State of Texas versus James Christopher Walls for arraignment.
Judge, we will need the indictment on this one. Yes. Judge, Mr. Wall's name is spelled correctly. He understands the charge against him as well as the range of punishment. Pleads not guilty and requests to be set on the pretrial docket.
All right, court enters Mr. Walls' plea of not guilty into the record, finds that he has waived the formal requirements of arraignment. Court sets Mr. Walls for pretrial hearing Is that March sufficient time for you, Mr. Manning, or do you need more time?
Judge, that'll be fine.
March 27th?
Yes,
All right,
Judge.
the court sets Mr. Walls then for pretrial March 27th at 1:30. Should he make bail, of course, his hearings will be at 9 AM on the same day.
Yes, Judge. Judge, I believe that concludes the folks that are in here currently. I am in receipt of paper for electronic signature for Ms. Harrison. So if I may have a couple minutes to go over that with her and we get my final people in here.
Okay, sounds good. We'll stand in recess until you get those ready.
Thank you, Judge. I don't know, I'm looking forward.
Shake my coat.
If it starts coming to the back of my head, just let me know. Yeah. Oh, okay. Judge, we're ready.
All right, is this Mr. Spencer?
Yes, Judge.
All right, this is cause number CR 25-25, State versus Clayton James Spencer for arraignment. Do you need the indictment?
Yes, Judge. Judge, my client's name is spelled correctly. He understands the charge against him as well as the range of punishment, pleads not guilty, requests to be set on pretrial for 3/27/25.
All right, the court enters Mr. Spencer's plea of not guilty into the record. The court finds that he does waive the formal requirements of arraignment. The court sets this matter for pretrial hearing on March 27th at 1:30.
Thank you, Judge. Judge, finally, I have Miss April Harrison.
Ms. Harrison, if you'll come up. This is cause number CR 25-9, State of Texas versus April Marie Harrison for arraignment. Do you need the indictment on Ms. Harrison?
Judge, actually, we're going to be resolving this case today on a lesser included criminal trespass. But her name is spelled correctly, and she understands the range of punishment for both charges. And as I said, she'll be entering a plea today on a lesser included criminal trespass.
Is that a class A?
Class B.
Class B. All right, and what will be the terms?
Judge, it's gonna be time served with a $0 fine, $0 restitution, court costs and attorney's fees. Judge, however, based on Ms. Harrison's continued indigence, I'd ask the court to take judicial notice of her application for indigency, as well as the fact that she has nothing for her when she gets out, and ask that the court waive those costs that can be waived.
What's the punishment time actually? You said time served, but what is that?
Judge, I believe we did it electronically. I believe it was 152 days.
163, I believe.
Sorry,
Since September 5th, Your Honor.
Yes, Judge.
I'm sorry, I didn't know this was electronic. Let me look. All right, Ms. Harrison, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand. Your name is April Marie Harrison, correct?
correct.
And Ms. Harrison, are you a United States citizen who reads, writes, and speaks English?
Yes,
Have you ever been diagnosed with a mental condition?
no,
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
yes,
Do you understand everything that you've read and signed in your plea agreement?
yes,
Where you have signed, is that your true and correct signature?
yes.
And Ms. Harrison, do you have any questions about your plea agreement before we go further?
No,
Mr. Manning, do you believe Ms. Harrison to be competent today?
I do, Judge.
And do you believe that she is entering into this agreement intentionally, knowingly, and voluntarily?
I do.
And you've explained to her rights as they pertain to this case?
Yes, Judge.
All right, Ms. Harrison, you were originally charged with a second-degree felony offense of burglary of a habitation. However, to the plea agreement today, as Mr. Manning has stated, would be for you to plead guilty to a lesser included offense of criminal trespass, a Class B misdemeanor, which could be punished up to a maximum 180 days in jail and a possible fine not to exceed $2,000. I see that the agreement is that you would be convicted of this offense, that you would be punished at 162 days in the county jail. You would receive credit for 162 days of time served. In addition, court costs would be assessed of $270 and reimbursement fees of $520. Is that your understanding of the plea agreement and what you're asking the court to approve today?
I believe he said he was going to waive.
Judge, as Ms. Harrison said, we would request a waiver of the court cost and attorney fees, but that is our agreement with the state.
All right, so Ms. Harrison, how do you plead to criminal trespass, a Class B misdemeanor?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
No.
Okay, then I can't accept your plea agreement if you're not guilty of committing the crime.
Okay, so
So,
Your Honor,
so why don't you take a moment and talk with Mr. Manning, and then y'all can let me know if we'll go further.
Yes, Judge.
while I was
Hold on,
alerted
hold on, hold on,
pending defense if
hold on.
prosecution stood it in a trial smear.
We'll stand in recess for a few moments.
Judge, we're ready.
Go ahead, Mr. Manning.
Judge, I think there was some confusion. Ms. Harrison was originally charged, as I said, for burglary of a habitation, and as I'd expressed to her after our review of the discovery yesterday, that there were some potential defenses and mitigation in that case that would have absolved her of guilt for the burglary of a habitation. However, she and I had not discussed the criminal trespass and the facts supporting that until today. And so I think there was just a bit of a confusion as to what she was pleading guilty to and her response for not pleading guilty to criminal trespass.
Okay. So Ms. Harrison, how do you plead to the Class B misdemeanor offense of criminal trespass?
Guilty.
Are you pleading guilty to that crime because you have in fact committed that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
All right, court accepts the defendant's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered, Judge.
All right, the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Rest in close, Judge.
All right, court is going to consider the evidence. All right, the court, having considered the evidence, finds that there is enough evidence to convict Ms. Harrison of criminal trespass. The court will follow the plea agreement today. The court convicts April Marie Harrison of Class B misdemeanor criminal trespass, assesses her punishment pursuant to the plea agreement at 162 days confinement in the Van Zandt County Jail. The court awards her 162 days credit towards her sentence for the time that she has spent in jail on this cause. The court assesses court costs of $270 and reimbursement fees of $520. Court, having considered the defendant's request to waive court costs and reimbursement fees, the court denies the defendant's request for waiver of those. So she is obligated to pay those. Ms. Harrison, when you're released, if you're not able to pay your court costs and reimbursement fees, you're to report to the courthouse and talk with the district clerk's office on the 3rd floor, and they can make it a payment arrangement for you, and you can pay those out as long as you will make a substantive effort to pay those, and we'll continue to work with you. If you do not, then the court will issue a warrant for your arrest. Do you understand?
Yes.
All right, you are hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted.
Judge, since it was an electronic plea, I don't think we have a thumbprint sheet at this point in time.
Okay, then we'll have to have one prepared and brought over there.
Thank you, Judge.
You're welcome.
Judge, I believe that concludes our business. May I be excused?
Yes, sir. I believe that does conclude all of our business there at the jail. Am I correct, Mr. Abraham?
Yes, Your Honor.
All right, then court is adjourned. Thank you very much.
Thank you, Judge.
Have a good day.